I'm not going anywhere.
But I am not afraid of you,
Mr. Chairman.
Not afraid of you.
Mr. Chairman, point of order.
Donald Trump has shown us in his first term and in this term, he is not loyal to people like you. He will cut you loose. This may be the last time I have a hearing with you because I don't think you're...
That rant of false information does not bring this country together. If you want to work on bringing this country, it's my time, not yours.
My God.
If you want to talk about
dividing this country,
it is my time.
I follow you on your social media posts that tears this country apart.
To address your falsehoods.
Oh, you can try all you want
in this country.
to not take responsibility for what you have said.
Time.
Sir, you're making a mockery of this committee. Sir, you don't tell me my time is over. The people of New Jersey tell me what my time is. You can't lecture me.
You can tell me my time's over.
You may be the charge of the FBI, but I am not afraid of you.
Mr. Chairman.
Not afraid of you.
That was not a scene from a political drama. That was a United States Senator and the director of the FBI screaming at each other inside a formal Senate hearing room until the chairman had to bang his gavel just to restore order. Now most coverage focused on that moment. The yelling. The chaos. The drama. But here is what almost everyone missed. Before that shouting match ever happened, Kash Patel made 3 specific statements under oath that constitutional lawyers and legal scholars are now examining very carefully. 3 moments. 3 statements. All of them sitting permanently on the United States Senate record. And in this video, we are going to walk through each one, clearly and factually, so you can hear exactly what was said and decide for yourself what it means. Because the most important story from that hearing room has almost nothing to do with who raised their voice the loudest. Let us start with statement number 1. And I want you to pay close attention to the sequence of answers, because what Patel said, and then said again differently within seconds, is where this gets interesting.
Confirmed to that position. And I wonder, did you then understand or have conversations with the White House about the intentions to do so?
Before I was confirmed?
Yes, sir.
Did I have discussions with the White House to remove FBI personnel?
Yes.
No.
So you're saying that you had no discussions with the White House before you were in the position about the removal of any personnel from the agency?
As I was preparing for my confirmation hearing, I had numerous discussions involving the type of people that would be employed and that those that were failing to meet the mark at the FBI would no longer be employed if I were confirmed.
And I'm assuming that mark had to do with loyalty to the Trump administration.
No, you're wrong.
Okay. Let us slow that down because the sequence of answers matters a lot here. Senator Booker asked one direct question. Did Kash Patel have discussions with the White House about removing FBI officials before he was officially confirmed to the job? Patel's first answer was no. Then, within seconds of that denial, he acknowledged having, and I am quoting directly from the Senate record now, numerous discussions involving the type of people that would be employed and those that were failing to meet the mark. So he said no. And then he described the discussions. Now Patel's position is that these were standard transition conversations about general personnel standards, not specific targeting of individual agents. That is his stated explanation and it is worth taking seriously. But here is why legal scholars are paying attention to the sequence regardless of the explanation. Before Kash Patel was confirmed as FBI director, he was a private citizen. He held zero legal authority over the Federal Bureau of Investigation. And federal law is very specific about the grounds on which FBI agents can be removed from their positions. Multiple legal experts cited in active court filings have stated that terminating agents based on their case assignments, specifically because of which investigations they worked on, is not a lawful basis for removal. Senator Booker said it directly in the hearing. Filing FBI employees based solely on the cases they are investigating is illegal. Patel disputed that characterization. And the debate between those two positions is now being decided in a federal courtroom in Washington, D.C. Because 3 decorated FBI veterans, Brian Driscoll, Stephen Jensen, and Spencer Evans, have filed an active lawsuit against both Patel and Attorney General Pam Bondi. Their complaint alleges what the filing calls a campaign of retribution against agents for, and this is a direct quote from the lawsuit, failure to demonstrate sufficient political loyalty. Patel disputes the allegations entirely. But here is the detail about Brian Driscoll specifically that you need to know before we get to statement number 2. Because his story is the human face behind all of this legal language. Driscoll served the FBI for 20 years. He led the Newark field office. He received the Medal of Valor and the Shield of Bravery, the Bureau's highest awards for exceptional courage. He was fired by letter on October 8, 2025. And that letter is where statement number 3 of this video comes from. But we are getting ahead of ourselves. First, let us talk about the grand jury. Because what Patel refused to answer, and the federal rule that allowed him to answer it, raises a question that has no easy resolution.
So I ask you again, did you testify before the grand jury that President Trump declassified the documents at issue in the Mar-a-Lago classified document case?
And that is why I took your invitation to work with the department and the court to have that transcript released. And the transcript is the best evidence of what I said then.
So you're saying right now this committee can have access to what you said before the grand jury?
To whatever was released. Under my understanding, Senator, that the Department of Justice
You and I both
released.
understand the law. Let me finish. I understand under Rule 6 of the Federal Rules of Procedure, a grand jury witness, in this case you, is not barred from sharing their grand jury testimony. This is an oversight hearing. This is germane to your integrity and credibility. You know right now whether or not you testified that President Trump declassified the documents at issue in the Mar-a-Lago classified documents case. Why are you refusing to answer that simple yes or no question right now?
Because the premise of your question is inaccurate, and
There is one federal rule you need to know to understand why that exchange matters. Rule 6 of the Federal Rules of Criminal Procedure. It governs how grand jury proceedings work in the United States. And it states clearly that a grand jury witness is legally permitted to voluntarily discuss their own testimony. They are not barred from sharing it. Senator Booker cited that rule by name. On camera. In a formal Senate oversight hearing. In front of the entire committee. And here is the factual situation that existed before this question was even asked. During his confirmation process, Patel stated that his grand jury transcript from the Mar-a-Lago classified documents case had already been made public. A federal court had specifically denied a news organization's formal request to unseal that same transcript. Which means at the time Patel said the transcript was public, a court had ruled it was not. So when Booker asked in this hearing, simply, did you testify that Trump declassified those documents, yes or no, Patel declined to answer. His explanation was that the premise of the question was inaccurate. He did not say what was inaccurate. He did not offer a correction. He did not say yes. He did not say no. Now I want to be fair here. There are people on both sides of the political spectrum who have genuine disagreements about how to interpret that response. Some legal experts say a straight refusal to answer a question you are legally allowed to answer, in an oversight hearing, is itself a significant institutional problem, particularly for someone whose agency is built on the principle of accountability. Others argue that the full context of the grand jury proceedings involves complex legal considerations that go beyond what Rule 6 alone addresses, and that declining to answer was a reasonable legal judgment call. Both of those arguments exist. Both deserve to be heard. And that is exactly why I want you to tell me what you think in the comments after this video. Because this is one of those questions where reasonable people with access to the same facts have reached very different conclusions. And I want to know which conclusion you have reached. But right now, we need to get to statement number 3. Because this one involves a letter, a specific constitutional clause, and a question that Patel also declined to answer.
We know 20 years of distinguished service to the FBI before you terminated him. Special agent in charge of FBI's Newark field office where he operated with distinction. Medal of Valor winner, Shield of Bravery awards. He's a patriot. You terminated Driscoll via a letter dated October 8th, 2025. And in that letter, you said that you were firing him pursuant to Article 2 of the Constitution. Well, you're not the President of the United States. And so I'm wondering under what authority you were allowed to terminate him.
that matter is under litigation, and I'm not able to discuss it.
Okay.
For words. That matter is under litigation. That was the complete answer Patel gave when asked what legal authority he used to fire a 20-year Medal of Valor recipient. And to understand why those 4 words are being examined carefully by constitutional lawyers, you need to know what was actually written in that termination letter. The letter firing Brian Driscoll cited Article 2 of the United States Constitution. Now, Article 2 establishes the powers of the executive branch of the federal government. It defines presidential authority. It is the section of the Constitution that gives the president his powers. Kash Patel is not the president of the United States. The FBI director's authority to remove agents derives from federal employment statutes, civil service regulations, and specific bureau policies, not from a direct invocation of Article 2. When Senator Booker asked Patel, "Under what authority did you terminate this man?" Patel cited pending litigation and offered nothing else. No statute. No regulation. No legal basis. Just 4 words. Legal scholars studying that letter have described the Article 2 citation as constitutionally unusual at best. The Driscoll federal lawsuit describes it as unlawful. The court will now determine which characterization is correct. And while that case works its way through the legal system, here is the data that exists right now on the public record from this hearing. According to the Cato Institute, a conservative-leaning think tank, approximately 20% of all FBI agents have been pulled from their primary investigative assignments for immigration enforcement. Now, after September 11th, the single largest national security emergency in modern American history, the FBI reassigned around 1,234 agents to counterterrorism. Under Patel, the Cato Institute figure puts the number diverted to immigration enforcement at approximately 2,840 agents. That is more than double the September 11th response. Not to address a national security attack, but to carry out an immigration enforcement agenda. Patel disputed the characterizations in the hearing and pointed to what he called historic crime reduction numbers under his leadership. But here is the one number that did not come from Booker or from any outside source. It came from Patel himself, in response to questions from Senator Coons about the pace of departures from the Bureau. 14 years. That is how long Patel estimated it would take to fill the vacancies created during his tenure. By his own count. On the official Senate record. 14 years of institutional rebuilding. For a law enforcement agency that faces threats that do not pause and wait. I want you to sit with that number for a moment. 14 years. Before we move on to what happens next. Because the legal timeline ahead of this story is actually moving faster than most people realize. There are 3 specific developments to watch right now. First, the Driscoll federal lawsuit. If it survives early motions to dismiss, both sides will enter discovery. That means sworn depositions from FBI and Justice Department officials about the specific basis for the terminations. The Article 2 letter will be central to those proceedings. Second, the grand jury transcript. The court's previous denial of an unsealing request is not permanent. Senator Booker's public invocation of Rule 6 in a Senate hearing creates additional legal and political pressure to address the transcript through congressional document requests or other formal channels. Third, Patel's position at the FBI itself. MS Now previously reported, citing 3 people with direct knowledge of the situation, that President Trump and senior White House aides had grown frustrated with the headlines surrounding Patel's leadership. The White House has not confirmed that reporting. What is confirmed is this. Every statement Patel made in that hearing, and every question he declined to answer, is now permanently part of the Senate record. In any future legal or congressional proceeding involving the FBI, that record does not go away. Senator Booker ended his time in that hearing with both a statement and a prediction. He told Patel directly, "I think you are not going to be around long. He will cut you loose." Whether that prediction proves accurate is something only the next few months will answer. But here is what we can say right now based on the verified public record. Statement 1. Patel denied pre-confirmation discussions about FBI personnel with the White House. Seconds later he acknowledged those discussions existed. His explanation is that they were standard transition planning. A federal court is reviewing the conduct that followed. Statement 2. Patel declined to answer a direct yes or no question about his grand jury testimony. Federal rules permitted him to answer. He chose not to. His stated reason was that the premise was inaccurate. He did not explain the inaccuracy. Statement 3. A termination letter for a 20-year decorated FBI veteran cited Article 2 of the Constitution. The FBI director is not the president. The legal basis for that citation is now an active subject of federal litigation. Patel declined to address it in the hearing. Those are the three statements, drawn directly from the Senate record, with no editorial opinion added by this channel. What conclusions you draw from them is entirely your decision. And I genuinely want to know what that decision is. So here is what I am asking the AVA Reports community to debate in the comments right now. Based on everything in this video, do the three statements we covered today represent legitimate constitutional concerns that deserve serious legal accountability? Or do you believe Patel's explanations are legally sufficient given the context he is operating in? And second question, yes or no, do you believe Kash Patel will still be FBI Director 6 months from today? Drop both answers below. We read every single comment. And the debate that happens in this comment section is exactly what this channel was built for. If you want fact-based, neutral coverage of America's biggest legal and institutional stories, subscribe to AVA Reports and hit the notification bell so you never miss what comes next. Thank you for watching.